Jack Smith's Deposition, Part 13, Accommodating Trump and SCOTUS's Immunity Decision. Welcome to Law and Society. What I'm doing is reading you excerpts from Jack Smith's deposition in front of the House Judiciary Committee. And the reason why I'm doing it is because it is important for us to keep remembering that Donald Trump tried to steal the 2020 election, and he incited an insurrection as part of his conspiracy to defraud the American people and the United States. So please remember to like and subscribe, and let's get started. I'm going to read the questions out first and then Smith's answers. Question: to the extent there's an allegation made that your office was coordinating with the state's attorney general's offices to have prosecutions go on in different prosecutions happen in the states, would you say that that did not happen and that would be false if somebody made that allegation? Smith: we were not trying to coordinate prosecutions with other offices, no. Then there's this discussion about questioning about whether Smith reached out or vice versa to Norm Eisman, Mark Elias, and Mary McCord. They're prominent election lawyers who are now bringing a lot of cases against Donald Trump's administration. So it was seemed kind of weird that that Smith would be questioned on this. Smith says that there was no coordination with those three. But it's weird that these private citizens would come up as part of Jack Smith's deposition about Donald Trump's crimes. Then the question: it just seems that at every instance when President Trump and his lawyers requested a little bit of delay because of cases they were defending, your office was not willing to indulge the request. Smith: it is correct that we were not willing to indulge delays that we thought were inappropriate. I will add, there were numerous instances where judges chided counsel for President Trump for trying to delay things. I'm thinking, as I'm stating now, I'm thinking specifically of the executive privilege litigation that we had, and this was in reference in our final report of him attempting to delay things. And so we agreed to dates that we thought were appropriate. All of that, as far as I'm concerned, was very public and transparent. What the dates were and the arguments to the judges about those dates were clear, and I thought they were fair and reasonable. Then there's another try to get Jack Smith to talk about the documents case, but he simply will not run afoul of the injunction. Then there's a question: after the immunity determination at the Supreme Court was decided in July of 2024, you filed a remarkably long brief in September of 2024. I think it was like 165 pages. And you know, the brief was very, very unusual in terms of length and content. What can you tell us about your decision to proceed with that type of a meaty brief? It's almost as if you were writing your special counsel report in that brief. Smith: sure. So as an initial matter, I think that the vast amount of factual material in that brief was not new. It was just in there to address the issues at hand. The context of this is we received this immunity decision. The immunity decision affected not only the indictment, it affected the evidence we could use at trial. And so for there to be litigation of this, the defense would have to know the evidence at trial. We would have to say, this is the indictment, and here the other evidence we're going to use at trial, in summary at least. All I understand, at least certainly I did, that this case was going to go up to the Supreme Court at least one more time for an interpretation of a lot of the questions that the Supreme Court left open, which we address in the final report. Our goal was to have that be one time and to have the evidence and the indictment get rulings from the court. If the defense didn't like them, they would get to appeal them. That would go up to the Supreme Court. We'd get a final understanding, and then we'd be back before the court to try the case. And so to do that in one trip as opposed to multiple trips, that just required us to go first, in essence, to put this there. And I said this earlier in the day. One of the challenges in this case is we had, in my view, a very strong case with a lot of evidence, and trying to condense that into a brief at that stage where we were not going to be precluded from offering things that we thought were important that could possibly be relevant to any of the immunity issues, but also have a fulsome brief. That's what we filed. It was my judgment that that was what was necessary. I think, again, if you look at that brief, vast majority of factual information in that brief had been in public or something close to it in the past. Question. And so the brief was filed right at the beginning of October, I think, or the end of September. Did you have any communication amongst your staff that this presented potentially a problem with the Justice Department's election year sensitivities guidelines? Smith. So when we got the immunity decision, we had a series of decisions to make. First was to look at our evidence and see, do we still have a case here? Do we still have admissible evidence that would allow us to proceed at trial? So that's what we did first. Once we determined that we did have that evidence, the next thing we did is, do we need to supersede the indictment? And because there was evidence before the grand jury that the Supreme Court had clearly said was immune, we determined that we needed to supersede the indictment. Once we determined that, we had to make sure that our conduct in going forward with an indictment and everything was complied with the election year sensitivities policy. And to that, we consulted the public integrity on the drafts of the indictment on our plan forward. And we set forth in the final report the public integrity concurred that we complied with that policy. This is one of those issues where this is why you consult the public integrity, because they are now keepers of that policy. And so we consulted with them and about the path we took, and they agreed what we ended up doing did comply with the rules. Question. So the question is, your 165 brief a month out from election, it seems from an outsider's perspective that runs the risk of impacting the outcome of the election. Smith. Yeah, we certainly were not in any way intending to affect the outcome of the election. And to make sure we complied with that policy, we met with public integrity to make sure we were doing that. They agreed, and they're the ones who enforce that policy. And so I felt comfortable taking the course that we did going forward. So with that, I conclude the 13th episode of excerpts from Jack Smith's deposition. Please remember to like, share, and subscribe, and I will come back with 14 in just a little while. Thanks for listening. Take care.